Oh boy, I am such a mess. I sat through that hearing today. I was at the end. I was put at the end, and it was a long wait just for the end, waiting for the end. But when they finally got to me, the room was empty, pretty much, except for all the paid employees, security, and the sheriff was there. He hung out because he had to go through the court process to give me my discovery. How many elected officials were in the courtroom? The Cade Foster, the sheriff, and the judge. I don't recall if there's any others. There's some guy in a suit in the observation area. I don't know if he was elected or not. But this lasted easily over an hour. One thing I can promise is that tomorrow I'm gonna get a CD for free from Judge Jones. He said I get a free CD in as an exchange for not recording in his courtroom. I don't even know that was really going to be an issue. I mean, they really provide good video in this courtroom, in this jurisdiction, this state. Completely different from Louisiana, where they don't allow any recording. They don't even let you listen to the audio. Plus, they don't even let you look at the police discipline records in Louisiana. So it's a big difference between these two southern states. One is more further north than the other. So it started out, we went through a discussion about me representing myself, and I had to break in and tell Judge Jones that I'm representing myself up to the point of the motions. And if it's really going to trial, I need a lawyer. And I asked him if he would appoint me a lawyer again. I let him know that the federal government doesn't frown upon that, upon lower courts appointing people lawyers, but he didn't. So I think I'm gonna have to hire a lawyer. And he told me today, though, he went through a list of awareness checks about asking if I'm aware of Kentucky law. He asked me, how long have I been studying Kentucky law? And I'm like, ever since I was arrested, January 3rd. So what was that? February 3rd, it's, what is the date? I don't know why, March 14th. So February through March, so over 2 months I've been studying Kentucky law, but I mean only the parts that are relevant to my arrest. So yeah, I got the run through, and I just wanted to clarify with him that I might still get a lawyer, and he even said I could appoint a lawyer at any time. But for right now, I'm going without a lawyer to settle these motions. All of these motions that I had submitted to the court, we have addressed. Each and every one of them individually with great care, getting input both from the prosecutor, me, and sometimes it came down to a matter of the prosecutor arguing with the judge, because the judge was kind of swinging my way, and he just argued for me. I was getting like stressed out, ready to argue against the prosecutor, but the judge just kept going, and I wasn't going to interrupt. And you'll see that on video. I didn't interrupt them. I let them argue with each other, but that was over talking about my YouTube videos, bringing my YouTube videos into the trial on April 19th. So let's see, we got motion to strike surplusage. Let's see, Jones said the citation is not going to be presented as evidence, so he didn't strike anything. We went through line by line about every little sentence that the Deputy Weldon put in his statements, but it's not really going to be used as evidence. I guess it's more about getting that testimony. And that's just going to be fun, dealing with the testimony of these cops, because they deleted their video and muted their video, their body cams. And they're relying on those idiots. They got to rely on those. Motion for bill of particulars. Judge Jones said the prosecutor already answered my questions. And what's interesting to me about this is that system where the prosecutor doesn't cover everything. All right, not everything goes through the prosecutor, even though pretty much everything goes through the prosecutor. Not everything goes to the prosecutor. It's a real stupid relationship. They're gonna call my witnesses and they can hold off on bringing forth witnesses until the last day before trial. The day before trial, bringing forth witness, and apparently they plan on bringing a pastor from the church, and they didn't name him. And I guess I didn't push that issue enough because I don't know the person's name, and we did not discuss that in court. They can wait until like the last day before they bring that crucial witness who didn't witness anything, really. All their witnesses are police, and they don't care about the background of their witness. They just they're just happy that the cop could still put on their uniform. But me, I asked for a little bit more from the witnesses, and I got their training records and discipline records, which I need to look at. I didn't even look at them. It's kind of a thick pile of paperwork. I guess I shouldn't be showing that on video. I don't know, I have to look at it first. Let's see, motion for discovery, but that also probably is compiled with the motion to compel discovery. The sheriff Norman will provide the names of the senders of these redacted emails. The judge kind of asked what the relevance was for the name of the sender. He asked if I needed the email of that sender. He asked if I wanted the name of the 17-year-old boy's name who got redacted. I'm like, nope, that's fine. I don't need the witnesses, or I don't need those, whatever they just people who are not involved with the case. Apparently the prosecutor said they're not even going to use these emails anyway. But still, we had Sheriff Norman swear before the court that he'll provide the accurate names of the senders of those emails. And I asked just for that, for background information, possible cross-examination in some way, possibly call them before the court to testify, the senders of these emails. But then the prosecutor says he may not even use the emails. They may not even use the policeman's report. What else? What are they using? Just police testimony. There's no other citizens involved. There's just police testimony. And possibly that's the mystery person. 3 cops and a mystery person. The prosecutor wanted the trial date moved from April 19th to another date because 2 cops were training on that day, and the judge denied that. I thought that was great because I was going to object, but the judge just said he'll deny it. So that handled that. Let's see, request for jury materials. I need to go back to the courthouse and ask about jury materials, about the mailing sent that's sent to the jury members. I want to read that. But what all is sent. But maybe I'll wait till tomorrow when I get the courtroom video, and then other people can listen to that and see the exact nature of what that's about. Judge Jones said he doesn't want individual names put in onto the internet, just general instructions. And he also said for jury instructions, that isn't exactly decided until right before the verdict. We decide after the trial and the closing statements, then we decide on jury instructions. I'm asking for early decisions on early jury instructions, but we apparently in this court, he follows the certain method which he doesn't want to go against. The Moore method. It goes against the Morgan. Ferretta, no. She got, oh man. There's a certain method he uses. It could be the Morgan method. I'd have to look again. I met with the prosecutors before. Are they going to destroy my computer with this? 8 gigabytes. And he said this is all the YouTube videos that he wants to bring against me at my trial. It's all in here in this 8 gigabytes he downloaded. It looks used. Should I return this? So I got to look at that, but it's not going to be introduced because the judge denied it. The judge denied these videos because it will be prejudicial. Too prejudicial. But yeah, I got all these 3 cops training and discipline records. Let me just take a peek. Oh man, the big certificates. He's been tested. Officer Ryan Burrow successfully completed something with drugs. So, oh, there we are. Kentucky Law Enforcement Council training history. And they wanted to get more training on my trial dates. I thought that was cute. Breath test, operator recertification. So I can go through those. I want to take pictures of all those documents that the sheriff provided. But that's not something that the prosecutor provides. But why doesn't it go through the prosecutor's office? The prosecutor wants to call these cops, but he doesn't want to know anything about their backgrounds. I mean, how does he establish foundation at the beginning of his examination without knowing the cops' backgrounds? I mean, it's silly. You think that they should provide it, but I had to subpoena the sheriff who wanted to go through the judge. And what's strange to me is now I got a subpoena for the police policies, which I should get for free. I got the training records for free. I should get the police policies, and we set a subpoena return date with the judge for March 21st, next Thursday. So when you get a subpoena, you have to put a court date. I put my court dates, of course, for today for the training records, and now I want to get more subpoenas, more paperwork, and I also want the radio traffic too. I can't subpoena the prosecutor. The prosecutor says they ain't got it, but it exists. The radio traffic exists, but I got to go through the sheriff's office again. I got to subpoena the sheriff's office for radio traffic and policies because the prosecutor doesn't care. And then they ask, what relevance is that? I'm like, come on. I don't know until I hear it. And I wouldn't ask for radio traffic if I hadn't gotten it in other cities. So it's not something this local area is used to providing, but it's been provided in other, it is getting provided in other, even in Natchitoches, Louisiana, I got provided radio traffic. So, you know, a southern state like that, if they're able to provide the radio traffic on the, you know, the radios that they communicate, then this city of Paducah, McCracken County is not above that. Let's see, I think I got it pretty much all covered here. It's all those motions, compel. Yeah, the judge doesn't want me recording in the courtroom, so he provided the free CD. Trial coming up. It's a guarantee. The prosecutor trying to be the nice guy, but he's just saying that. He isn't. He's the enemy. He said it to me. He's trying to be the nice guy. Are you kidding me? You're the prosecutor. The nice guy is supposed to be the judge, not you. You're not fooling me. You may fool a lot of other people, Mr. Newburn, but you're not fooling me. You're not the nice guy in this whole thing. We're in an adversarial relationship. You're the enemy. You're not the nice guy. I mean, you put his feet to the fire and you find out how nice he is, okay? You try to get him to dismiss your case. If you were really nice, you'd just outright dismiss my case. But instead, he wants to go through with the trial because I was willing to settle for 2 months of this deferred program where they wouldn't rule on anything for 2 months and then let it go. But instead, they started with 9. They went scaled back to 6. They wouldn't go to 2. We could have had this done with 2 months deferred, prosecution. And apparently I was looking at the wrong law. I was telling him about the law on deferred prosecution. It's called Kentucky Rules of Criminal Procedure 8.04. I was looking at. It's called pretrial diversion. And then I explained that the limitations, the agreement may not specify a period longer than could be imposed upon probation after conviction of the crime charged. I was telling him that my crime doesn't have any probation. And so he tells me that I'm looking at the wrong law. And he wouldn't tell me the right one. He's saying that 8.04, that the guy that shared that law with me yesterday, I appreciate that because I referred to it and now I get the prosecutor telling me that it's the wrong law. So now I'm questioning myself. It looks like the right law to me. I don't know what, he wouldn't say what the other law was. He's just they're playing with me. He's not being a nice guy with this. And then the prosecutor, Cade Foster, admitted to being wrong in court today when he said that he said that the emails came from the church. He had admitted to being wrong. Oops. Oops, I just put a guy in jail. My bad. All right. That's what they do. They make mistakes like that. And then it's just like, oops, my bad. What I should have done. Well, actually, I got this motion to try to get rid of my prosecutors. But I'm like, I should have said to the judge, I want them sanctioned for their mistake. I didn't even think to ask that. And now I'm thinking about that. In court, I should have been like, right after Cade Foster said, oops, I made a mistake, I should have been like, I want them sanctioned. But we'll go bigger than that. We'll try to get them excluded from the case for these bad, like life-altering, life-changing mistakes that affect my future. All right, their mistakes affect my future. You can't just make mistakes like that, leading me in one direction, having me believe that, these emails came from the, oh man, what's that? Oh, another one of these. I got all kinds of these stupid bugs in my car. Oh, he's stuck in here. So, somebody's spying on me with those things. So that's a mistake. That's costly, but all they do is throw up their hands and go, oops. And the judge didn't say anything. I had to suggest. It was on me to suggest they get sanctions, and I didn't, and I dropped the ball on that one. I was so stressed out though. Let me finish this to 20. Alrighty.